It's my pleasure to welcome you again to another edition of Real Estate Services and Transactions, alternatively known as REST. My name is Oluwafemi Sanusi. REST is a subsidiary of Real's Academy. Today we have in the house ESV Olaliko Aboderin. He's an estate surveyor and valuer with wealth of experience in real estate. He is the lead advisor of Olaliko Aboderin Consulting, a firm of estate surveyors and valuers. He is also the director of studies, Real's Academy, a real estate training center that are into the development of professional real estate practitioners. Thank you, sir, for joining us for another edition.
Thanks so much.
Now, sir, in the last edition, you discussed extensively about freehold interest and leasehold interest. Now, under that freehold interest, you mentioned quite a number of things like Feesimple, fee-tail, life estate, etc. And I realized we didn't really have much time to, to expand on each of all those things. So I would like us to start on that note today to focus on those areas of freehold.
Okay. I think, yeah. What in that episode, I remember, we discussed about types of interests.
Yeah.
And under the English Doctrine of Estate, we identified the various type of estate interests that exist there. We were unable to explain each one of them. It's important actually for people to know, but I mentioned in that episode, if you recall, these types of estate in land, they equally exist in Nigeria. We identify Feesimple, we identify fee-tail, talked about life estates, talked about estate for revival, which is conditional estates, the form of co-ownership in terms of joint tenancy, tenancy in common. We have profit appendary, we have way leave, we have all sorts of different types of interest in that. Now, the Feesimple is a form of inheritable estates. It's called so-called Feesimple because it's an estate that anybody can simply inherit from the holder of the right in land. That means that is a form of freehold interest that can be passed to anybody after death. There is no limitations as to the exercise of that right. But where it is a fee-tail, it's limited to the heirs of the body, or let me say the heirs of the holder of that title. The heirs means the surviving children. That's the heir in law. So it's only the surviving children of the holder of the title that can inherit the property where it is a fee-tail. And you see, the creation is the magic words of expression used in title that normally give these different forms. If I'm sure you must have seen title, particularly in the area in form of conveyance in the olden days, that they will say to Femi Sanusi in Feesimple. Femi Sanusi in Feesimple. That expression automatically creates a Feesimple interest in favor of Femi Sanusi. Right? But it's equally possible that the expression will say Femi Sanusi and the heirs of his body. Instead of saying Femi Sanusi in fee-tail, you can have it Femi Sanusi, Green Acre to Femi Sanusi in fee-tail. But instead of even using that expression, you could say Green Acre to Femi Sanusi and the heirs of his body. That has delimited whoever could inherit the property. So it's only the heirs, that is your surviving child or children, that can inherit such. That is the case of fee-tail. Now I've given the expression how such can be created. That can be a form that will readily come to mind is under will. The man that has it before, in his last testament, he was like, okay, I'm giving green acre to Femi Sanusi, and only for the benefit, thereafter him for the benefit of his heirs, of his surviving children. So it can be created, and we see instruments creating all these things, particularly will creating this kind of a thing. So where that happens is, if it is a field tale, then it's not an open inheritance.
Okay.
Now the question would be, what if the person does not have surviving child, any surviving child? Yeah, the property will cheats.
Okay.
It will revert to the state.
Okay.
That's just the meaning. It will revert to the state.
Okay.
And investors, buyers should be, should be aware of this.
Okay.
It means when buying property, we should have proper study of the title. It's not enough to just, on the face of the property, seeing it as, in the face of title, seeing it as a registered title. And you say it's registered. Oh, okay. The person, when he died, he will it to his uncle. If he's in a field tale, he cannot will it to his uncle. That right he does not have that right to exercise.
Okay.
So, equally, apart from that, we have what we call life estate.
Okay.
Life estate is for the lifetime of the holder.
Okay.
Right? It could be created by saying to Olalekan Aboderi, so long he lives. Or to Olalekan Aboderi, for his lifetime. That automatically creates life estate. Estate for life. So long I am alive, I reserve right in the property. But on my demise, my right ceases. In fact, death equally, as I'm demised out of the world, the death demises that right. It puts an end to that right when you have your last birth.
Okay.
That is the kind of life estate. It's for the lifetime of the person. And the moment that the person dies, it can happen. Again, let's say under will. Let me give you a scenario that we have seen. Think of somebody who has assets, is worthy, and for whatever reason, he has, excuse me, he has a wife who unfortunately does not have children. Okay. No child for him. And in his will, he wants the wife to benefit, but he does not want maybe members of the family of his wife to be entitled to his asset. He can delimit who is going to benefit by saying to my wife, so, for so long she lives. That creates a life estate. So that is another type. And if anybody, for example, now let's say a will passes such to an individual, right? Then it's important to critically look into the legal implications of buying such a property. Let's say after the death of the beneficiary. Because the moment he dies, his right in land ceases. Again, something close to that life estate is what we call estate portfolio. Okay. But in this case, the root of it, the tradition of it, was from the life of another person. Okay. Green acre to Femi, for so long Olalekan Aboderi lives. Okay. You can look at that. If tomorrow I die, your right ceases. That is the estate portfolio. That was the root. Okay. Of estate portfolio. Okay. But and it's called conditional estate. Okay. This conditional estate, the condition has now changed over time. There are a series of other conditions attached to this now. Okay. A good example is plots 1, block 3 in favor of Olalekan Aboderi. For so long, he remains a member of this organization.
Sorry to cut you, sir. Though I don't think I'll mention the name of that. But I think there's a religious organization, Christian organization, actually, that practices something similar.
Yes, but that is not for us to mention. Yeah. And that's a very good example. We don't know others, but I know one. And they have very big land holdings, and they allocate these land holdings. So under the terms, under this same type of estate, plot so, block so to you for so long, you or any members of your family, your immediate family, remains a member of this religious body or this organization. That is estate portfolio. That is conditional estates. The moment, even in your lifetime, the moment you cease to be a member of that group, that organization or that religious body, your right ceases. There is no argument about it. So it happens. That is to tell you that all these estates in land, they are in Nigeria. You see them everywhere. Now, let's go to co-ownership.
Okay.
The case of co-ownership is where more than one person, 2, 3, multiple individuals come to acquire a parcel of land and hold the purchase as if it's one single person.
Okay.
That is case of co-ownership.
Okay.
Now, this case of co-ownership cannot take the form of what we call joint tenancy, or a case of what we call tenancy in common. Okay. Don't mind the word tenancy there.
Okay.
Right? Joint tenancy or tenancy in common.
Okay.
Where more than one person decide to acquire a parcel of land together as one single buyer, they will take the form of joint tenancy where there is unity of possession. Okay. Unity of possession will be a case where none of them can lay claim to any particular portion of what have been bought, or any proportion of what has been bought. Any portion or proportion of what has been bought. It means there won't be word of severance or any clue as to the word of severance. Any clue as to how to share in proportion or different portion for different members of the group. Where there is nothing like that, then we'll say there is unity of possession. They hold together as if it's just one person that has bought. Right? Then when that unity of possession is there, equally there will be another unity. Automatically, of course. That is unity of title. All of them will derive their interest under one paper, under one deed. The title, with their right will be evidenced by one single deed. Then we say there is unity of title, making two unity. The third one is that there must be unity of interest. The 2, 3 people can have derive right under one title but no unity of interest. Like, for example, if the two of us derive right title under one, right interest under one title, and they say Green Acre to Olaleka Aboderin for 20 years, remainder to Femi. Both of us are spread out in the same title. Is that not so? We are granted invested interest in the same title. But while my own is in possession, your own is in remainder. It's not the same interest. It's not the same interest. But for it to have unity of interest, that title must necessarily create one single interest and first that single interest in all of them together, jointly. So it can be that a right of occupancy for 99 years vested in the 4 of them or the 5 of them or whatever. That is unity of interest. It must be the same interest that and is vested in them as if they are one single entity. Now, then there must be unity of time. Unity of time is that, while they obtain their interest under the same deed, that deed must be signed, must be executed at a particular point in time. Not that they have different deeds executed signed differently, or that the right in land is vested in them under different time. Like the example I've given to you. Your own right will not start running until after the 20 years of my own, in the case that I gave as an example. So in that situation, then if we have these 4 unities, it's not compulsory. I'm emphasizing this because on the page of the deed, there might not be an expression that states that this is joint tenancy. But when you read the deed carefully and analyze the provisions in the deed, and you are able to establish these 4 unities, then the rights that have been created is what we call joint tenancy. And that's very dangerous. And it is joint tenancy. Very, very dangerous. It has a lot of implications. The moment the right to land It's identified as joint tenancy.
Okay.
You have the 4 unities.
Okay.
Then we will say there is what we call right of survivorship.
Okay. Okay.
That right of survivorship implies that is the surviving tenant, the surviving one, the last surviving one among the owner that will have the finality of ownership. Okay. In respect of joint tenancy. Okay. It's a tenancy in common where there can be clue as to portion for each, our proportion that each of them will lay claim to. And to achieve that is by using word of severance. Okay. If the 2 of us acquire a parcel of land, we can say to be shared in equal proportion. Okay. Or to be shared in ratio 70-30. Okay. Or to portion, half of it in facing so belong to be held by Femi Sanusi, while the other parts to be held by Olale Kabodere. That becomes tenancy in common. Okay. So apart from all those ones too, we equally have other rights. Okay. Like apparent right is there. Okay. Apparent right is the right to fish downstream. Okay. You have profit appendary. Okay. Profit appendary is the right to harvest. Okay. In terms of farmland and things like that. Okay. Then we have what we call easement. Okay. Easement is actually a right in favor of another property where there is need to exercise a right of way. Okay. It can equally be right for access to natural light and what have you. But easement cannot exist in absolute sense in respect of a parcel of land. There will be another property that suffers it, which will constitute like a restrictive covenant against such a property. Okay. And that's why D&M says that proprietary rights in land has space dimension. And that space dimension is an abstract attribute. So because to properly identify the size and shape of your land, you need to study the deed too, whether there is an easement in favor of it or whether there is a restrictive covenant against it. So these are the different types of estates that we have within the doctrine of estate, and they are in Nigeria. I remember a friend whose father, in will, stated that about 4 of them should have access to one property. And that my colleague was like, Baba has created joint tenancy. But when we read it properly, what Baba has done was to create a joint tenancy in common. Because he equally put that the proceeds from the property should be shared in equal proportion. Okay. So there is word of severance already. Okay. So it's everywhere. Just like you identify the estate for Otrivaya, that we have it equally in Nigeria.
Thank you very much. Viewers, I know you have questions and suggestions for us. So please remember to send them to the information at the bottom of your screen, and we would answer them. Please remember that we have social media platforms where you can also follow up on us as well. So we'll be willing to hear from you. Thank you very much, sir, for being a part of.
It's indeed my pleasure. It's indeed my pleasure.
So until next time, my name is Oluwafemi Sanusi. Take care, stay safe, and God bless you.